Good morning. Let's talk a little bit about conflict of interest. Um, this morning, it is a topic that is not very talked about. Um, a lot of attorneys and clients alike, they seem to brush the topic aside at the beginning, mainly because that if attorney did not take the case because of conflict of interest, that's the lost revenue for them. Oftentimes, the client believes that if they can get together with two or three similar clients and share the cost of attorneys, then that will save them some attorney's fee. So, oftentimes, the issue of conflict of interest does not arise until the later time in the litigation, which is a lot messier. So, two situations where conflict interest will arise. One is we call successive representation. That means that if I represent Bob 2-3 years ago, and now David comes to my office and want me to represent him because of the issue that he has with Bob. That's a conflict of interest because I'm in the same time I'm representing a new client suing a former client. That's a no-no. In court, in that situation, will determine whether or not attorney learned a secret about Bob that will add David in this situation. So that's the situation we call successive representation. The other situation is really called multiple representation, where we represent two or three or more clients in the same lawsuit. Client always want to share costs with attorney's fee, and that's understandable, but oftentimes we find that each one has their own interest. For example, they have different opinion about the direction of litigation. One want to settle, the other one want to move forward with litigation. That's another example. And sometimes the most often is at the end, if defendant side needs to cover up with the settlement, oftentimes defendants will point a finger at each other as to who is more at fault. So that's where the situation become sticky. Now, two types of conflict of interest. One is potential. We know that some, and the other one is called actual conflict of interest. Obviously, if there's a actual conflict of interest, the attorney cannot represent the client, and if he is currently representing the client with actual conflict, then he must withdraw from the case. That's the easy one. The other one is not so easy, is potential conflict of interest, where clients are cordial at this time. We give disclosure in writing that we are there's a potential conflict of interest later on down the road, and as long as the client understands the potential conflict of interest, then oftentimes the attorney will agree to take on the case. Now, I believe that there's the reason I don't recommend that you have a multiple representation, and something that you need to think about before you hire attorney, is that there's a lot of secret you want to share with your attorneys, and you want to retain the attorney-client privilege, and if you have too many parties sharing one attorney, it's hard to retain that confidence that whatever you share with your attorney will not be shared to the other client. That's the most important thing. So if if you have a situation that is very unique, and you need to have that confidence in your attorney to retain the information that you provide, that might be vital to your case. It's always recommended that you have your own attorney, and there's a reason for that. So if you have any question, leave a comment below, or private message me. Again, this is providing general information and not for legal advice. Always consult with your attorney, but if you do, welcome to leave a comment, then or private message me, then we'll chat about it in further detail. Bye.